In January of 2015, Lisette Gonzalez was arrested for driving on a suspended license. At her trial, a jury had found her guilty, and Judge Fred Schott had handed down a sentence until he began reading into her previous DUI arrest that suspended her license in the first place. As it turns out, Officer Michael Wagner testified that he saw Miss Gonzalez drinking from a can of natural ice while driving. Officer Wagner took Gonzalez to the Seminole County Jail, but testified that no one qualified to perform an alcohol breath test was present. So he just checked the box, saying that she tested above a .08, the legal limit, suspending her driver's license, booked her into jail, and left. 2 months later, she was caught driving on the wrongfully suspended license. But now, with the new information, Judge Schott determined that her license should have never been suspended in the first place, as her DUI was only possible because the officer had perjured himself.
If I could be heard on that matter, I was going to ask...
Before you go there, I want to be enlightened. I didn't think your license got suspended for 6 months just for getting arrested for a DUI.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months, and now get arrested.
Yes, he did, Your Honor.
For nothing. Yeah, so you're going to no process that case? Or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point,
wait a minute.
that we're willing
Did you hear
to
the
do,
uncontroverted testimony of this officer?
Your Honor,
Yeah.
regardless of...
Tell me your position.
Yes, Your Honor. The DMV...
Give him some work.
...is in charge of suspending licenses.
Yeah, when officers lie to them...
Correct, Your Honor, and that's why patrons...
Then I want you taking him on perjury.
I've never had a situation where I heard a lawyer talk to a judge like this. Do you know whose court you're in? Lower your tone. Talk to the man with some respect. I've never heard a judge being disrespected like that before.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing.
The state's position,
I'm dismissing.
You cannot
I am
dismiss,
dismissing.
for us to be able to respond to.
No, I'm dismissing the charge.
What situation could a state attorney argue with a judge for a mistake that a citizen made? Your Honor, it was an accident. Please let the citizen go. But a cop does it. Oh, please, it was just, it was a mistake. She's still guilty. Based on what evidence? The evidence that he manufactured? Oh, God. Imagine how many people have gone down for things like this, where there wasn't somebody who looked into it and made it right. Imagine how many people went to jail, ruined lives, because somebody like her is sitting there arguing to send somebody to jail with no evidence. Disgusting.
You can appeal.
We will, Your Honor. Please provide us a written order.
No. I'm dismissing the charge.
So there will be no court minutes or whatsoever.
Sua sponte, based upon this record. And that case has the same record as this case. So take it up on appeal with him lying about it and getting her license suspended.
And I won't let that be said today. He admitted to the mistake today. Patrons and people who have identifications
this whole case was
and driver's
fishy.
licenses.
How is that a mistake? He explained his actions. There's a difference between, oh, look, I accidentally put this in this box, and saying I put it in this box because of this reason. That's not a mistake. That was done on purpose. He's rationalizing why he did it. All this lady's screws are loose. This is proof that just because you're educated doesn't mean you're smart. Just because you have a degree don't mean you know everything, because she's missing the whole point. Or is it me? Can't be too infallible, right? But I think she's missing the whole point.
I have no idea how they...
To keep their address on file.
You know what?
The state intends to amend the charge and proceed on its own value.
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on the other charge?
I'm granting JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not... No, I've reconsidered all of the testimony and the evidence, And you know, now that I
The state would
consider,
like to be heard on that
now that I
matter.
consider what Officer Wagner testified to and how many times he basically tripped over himself unnecessarily just to arrest this lady with no real probable cause. We should have had a suppression hearing. I'm granting the motion for jail.
The state would like to be heard on that matter, Your Honor, as they're entitled to be heard.
Sure.
Today we've proven, as Your Honor initially indicated, until such time as the state was not able to tell you why we're proceeding on the charge that we were proceeding on, the state intended to amend that to either a civil infraction and or a no valid, but the state needed time and intended to do that. However, in this particular case, there was ample testimony as to the fact that the defendant's own statement that she was in possession of alcohol and she drank it. There was testimony uncontroverted from the defendant that that was in fact alcohol and she normally doesn't. This is again.
What does that have to do with the point that the actual evidence that shows that she was drinking and had over the limit was fabricated? What does that have to do with anything? It matters not what the woman, because again, let's be real. Hey, I'm probably gonna get in trouble for this one, but it's not illegal to. I'm not gonna say it like that. I don't believe the crime is to have a drink and go on a stroll through the park. I believe there is a reason why there's a breath test and there's a limit set. Because at the end of the day, it's not just you go take a swig of anything and you're drunk. Your blood alcohol level needs to be above a certain reason. That's why that test is necessary. Because you can't just say, well, subjectively, I believe this person is drunk. You can't say that. You need a measurement. You need something that is unambiguous and tells you this is what's wrong and this is what's going on. And that was fabricated. It doesn't matter what she admitted to. Because even if she did have a drink, if she was still below the limit, I don't think you could charge her. Somebody correct me in the comments if I'm wrong. I don't believe you could charge somebody just for having a drink. There's a reason why there is a limit.
It's direct evidence and not circumstantial evidence.
Mm-hmm.
Furthermore, there was bad decision making, there was balance, there was sway issues, and everything else.
Mm-hmm. You mean from the line cop?
For the defendant. You're done. Now, you still have this other criminal charge. I'm not dismissing that. The Willis, we're going to go full bore. We'll get DMV people in here. We'll get Officer Wagner back here, and we'll find out why your license was suspended if somebody broke the law to cause your license to be suspended. And that's the route you wanted to go.
No, Your Honor,
So
that's not
really
the
Is that another case on your docket? I
Yes,
heard
it
that
is
was
on
your
my
docket
docket.
in both. Okay, I just wanted to make
We'll
sure.
see
'cause I
where that
heard
goes.
it was. Okay.
Motion JOA is granted.
Your Honor, I believe it would be judgment notwithstanding a verdict.
Judgment notwithstanding.
And you're not going to provide a written order on that?
Nope. No need. It's in the minutes. Want to appeal me? No.
The judge absolutely has the authority to overrule the jury's verdict, but it is rarely done. The morning after this incident, the judge changed course again and filed a 4-page order saying that he was granting a motion for a new trial, although no one had made such a motion. Ms. Gonzalez's defense says that because she was acquitted, any retrial would violate her right to not be prosecuted more than once for the same offense.
The same
And
crime.
after all of this, Judge Schott was removed from criminal trials. He was then reassigned to a civil docket. In a statement, he said that he sticks by his decision, but he admits that he shouldn't have gotten so mad at the prosecutor, or granted a non-existent motion for a new trial after apparently acquitting the driver. And in the end, the officer maintains that it was merely a mistake. But I'd like to know what you think, as this case does not appear to have been appealed or retried, nor does it seem that Ms. Gonzalez has filed a civil suit against the officer or prosecutor. And of course, the officer was never charged with perjury. Let me know what you think.
What I think is that if a person who is a citizen would have perjured information or even put the wrong, for Pete's sakes, if you go apply for a gun and you check the wrong box, it's a crime. But that officer was able to check the wrong box on someone losing their license and being suspended or whatever the case might be, and basically setting them up for jail time. And that was perfectly okay, though. That was perfectly okay. Nobody had a problem with that. Come on now. It's just the double standards. And I, I would be a little bit worried about going through another trial in that setting. The judges, he seemed like he was doing a pretty good job there, but he ended up reversing the trial and saying, yeah, try the person again. I don't know about that one. I don't know about that one. And at the end of the day, why would you want to go through another trial with a prosecutor that clearly doesn't care about whether the person actually committed the crime? They clearly don't care that the evidence was fabricated. Clearly cares about none of that. Why would you want to go through another trial like that? I wouldn't. You wouldn't trust it. Trial by jury? Yeah, yeah. Look how much luck that did. They went the whole trial by jury, and there was no actual evidence, no tangible evidence. Eyewitness, okay, that's she lied. She told on herself, right? But again, I think there's a reason why there's a number and there's a limit you shouldn't cross, because otherwise you're just saying, well, I think that person looks unsteady. I think this person looks over the limit. How is it an accident to fully and completely make up someone's blood alcohol level? That's not an accident. That's done on purpose. It's, I believe his decision was right in the first place to throw out the entire case because it's built on a false premise. Guys, thank you for kicking it with me for another video. I'll see you in the next one. Peace.